I give this a lot. That's the objection mentioned for item number 34. This was listed in the code number 16. The order has been complied.
Close group officer said.
Close group. This was listed.
Daily list for motion item 2.
Lordship, move this matter.
Yes.
Lordship, in this matter, your Lordship directed the principal.
1 to 9.
Item 1 to action.
Your Lordship directed the principal Presidas Commerce College, my lord. We personally present, your Lordship. Lordship, he is a member of the National Council, National Policy, your Lordship. More particularly, your Lordship.
Let him be a member, but our work also has to continue.
Lordship, Vice Principal is there because of he has been sent by the government of Assam, your Lordship, to attend a meeting in Delhi, your Lordship. Vice Principal, he is coming. He has come with the records, your Lordship.
Where are the reports?
Lordship here.
Records of all the candidates.
Yes.
Does it
In the third
contain,
semester.
does it contain his application?
Lordship, may I, if your Lordship permits, may I submit? Lordship, and to clarify certain points, your Lordship. Here,
No, question is,
Yes.
one student was not given admit card.
Yes.
Okay.
My,
Guwahati University is refusing to declare the result because he appeared without admit card.
yes, your Lordship.
He was allowed by the college authorities to appear.
Yes.
Guwahati University says that the application of the candidate was not forwarded to them for the purpose of issuing admit card.
My lord.
Candidate says that, yes, I have submitted the complete application.
My lord.
College says you have not. So first question is, did he submit his application or he did
Yes.
not?
He submitted his application because it's a lot of form fill up is made by the in the website by the candidate itself to the web portal, your Lordship. Candidate itself fills up the
Understand,
forms,
did
my
he
lord.
make or he did not make?
He make, but it was a defective one, my lord. Because your Lordship, if your Lordship.
So now, for some reason, if there is an inadvertent defect,
Yes,
because you have introduced system of website, we have
Yes.
introduced system of computer,
my lord.
which is supposed to enhance the system.
Yes.
Are you bringing down the system based because of a small defect here and there?
Lordship,
See,
yes.
Had it been a manual application, the college would have told him that please correct it and give us back the corrected one. Are we to understand just because it is website, the student will lose 1 year?
No, no, my lord. May
Then
I
rectify it.
clarify?
How you rectify it?
Lordship, he has to do it. But we have Lordship asked, we have requested him to rectify the errors.
Who will rectify?
The candidate himself.
Get it rectified.
Yes, ma'am.
Because we have sent all the papers, he said in the examination.
Definitely,
appeared
we
in five
can't
subjects.
accept for some mistake
My
in
lord.
the application in the website, a candidate will lose 1 year.
Lordship, that is not.
That's the bottom line. We are never going to accept it.
Lordship.
If necessary, we'll ask you to bring down your website, go back to the manual system.
Lordship,
If the website is an obstacle for all these kind of things.
Lordship, one factor.
Do the necessity, correct it.
The portal,
Who?
Guwahati University. So that is
Definitely, they'll, moment you saw that there is a defective application, if you are now allowing him to rectify, why didn't you
that
intimate?
time only we have requested.
Mr. Madam, why didn't you intimate the candidate? We found your application to be defective, please correct it.
Lordship, we have
Where is your communication?
verbal communications, my lord.
Verbal,
No,
Because-
no, madam. We-
Verbal communication
verbal
of
communication
times.
and no communication, it's one and the same.
Lordship, may I'm sorry for.
See, you are dealing with a career of a student
Lordship.
and the colleges are established to enhance the career of
My lord.
students, not to suppress the
Lordship,
careers,
I'm-
mind
I'm-
you.
admit, my lord.
This is the basic
My
purpose
lord.
of our colleges
My
and
lord.
all.
This candidate, he appeared in all the 5 subjects. We have forwarded all his papers to the committee itself for Lordship scrutiny. And the committee has forwarded to the Guwahati
Which-
University.
What committee?
Lordship, it's a Examination committee, my lord.
Of whom? Your college or
Yes,
university?
Commerce College. His name found in all the places. In the top sheet, it was forwarded to Guwahati
How can
University.
you accommodate? You ask information from your authorities. That they are making a statement that initially there was a defect in the application form, in the form submitted in the website. Later on, some committee was constituted, committee rectified it.
That is, no, committee has been rectified by now.
Then
His attendance sheet as well as answer script has been forwarded to the committee who scrutinized the papers. Scrutinization committee, my lord, for evaluation of answer scripts. All are with them.
evaluation of answer script will be by
Yes.
the college or by the university.
University, Joan, my lord.
Then why did you open the answer script then?
No, we did not. We did not. Lordship, may kindly have a look at our,
No, we are not.
Yes.
We want a solution to this. Find out
My
how
lord.
you do it. Tell us.
Lordship, they have
We are
opened
taking
the
up,
hotel.
we are taking up around after 2 hours, around 12 o'clock. Tell us how you discuss, how you find a solution.
Can it be a true lordship?
Okay, at 2 o'clock. But bottom line, Mr. Vice Principal, we can't allow a student to suffer because of all this.
Lordship, he said.
Students, we are always in their
Yes,
favor
yes, even-
because they are students.
My lord,
They are at a very tender age.
lordship is very much
They
correct.
may know something, they may not know
They may
something.
not know some.
Colleges are supposed to be mature, governed by
Yes,
mature people.
Yes,
So your maturity should prevail over the immaturity of the student and guide them in a proper way so that their ultimate purpose is achieved.
Lordship, at this stage, my lord, you will open the door only.
I
in
don't,
favor of the
you take
academic-
it up amongst yourself.
Oh,
Otherwise, we'll pass an order, bring down all these websites, this, that,
yes.
go back to the old classical system of,
Manual system, our old system.
because technology cannot be an obstacle. Technology is always to enhance the system, performance of
Lordship's
system.
correct.
That cannot be an obstacle for a student.
So we allowed him to sit in the examination.
I know
He
you're
appeared.
very good, but your allowing is not serving his purpose.
Lordship.
We want,
Lordship, my difficulty having matters in Kota.
we are not interested in
No,
personal
no,
difficulties.
no.
We are interested in the welfare of the student. That's all.
4 o'clock, my lord.
Do whatever it is. We'll take
And
it
if it's-
again today, find out how you
Lordship.
amongst yourself discuss, tell us a solution. We'll put it in our order.
Item 4,
May it please your lordship.
Yes.
My lord, by order, it is 1610, my lord. The council for the director elementary education was directed to obtain instruction in this mail. Order it is 1610, my lord. And lordship has paid the in order. My lord directed the council for the education to obtain instruction as to how and why the petitioner was brought down
Just
from
a minute.
end,
Yes, Mr. Kaushik.
my lord.
Please, let us pray for taking up after some time.
After some time.
Thank you. And the petitioner has challenged the impugned order 24 to 2022, my lord, on the ground that the
Supreme Hall and Council for a petitioner seeks adjournment. That is the last order. That's the only order.
my lord, as per seniority list, my lord, page 18, seniority list, page 18, my lord.
To allow the petitioner to be the in charge headmaster by recalling the order dated 24/2. What is 24/2?
24 to, my lord, the impugned order.
Page number.
Page number 23, 23.
implement order is of February 2022.
I noticed it. Manik Borua is hereby allowed to hold the charge of headmaster along with financial power. So you want this order to be set aside.
He is not having the B.Ed degree.
He does not have B.Ed degree. Where is your statement?
In the annexer 3, it's on page 18, my lord. This is the draft copy of the list, my lord, where is the
Annexure
data is
3,
given.
page 18.
18.
It doesn't bear any signature or nothing, lordship. It's just a statement. Anyway,
So Chisti, if it is wrong, tell us, we'll draw contempt against him.
I'll have to. get
No,
instruction on
before you verify,
Yes.
if it is wrong, we'll draw contempt.
that. Then, right
But
now,
as long as it
As
is not wrong, we are bound to take note. It's a part of the record.
even then that I'm,
And these are all computer generated.
yes,
It must be available in some portal, some website of the authorities.
it is under the signature of headmaster of that particular school.
It must be there in the school. And who is the petitioner?
Serial number 2, 44.
Kotik. Okay, Kotik has B.Ed. This man does not have B.Ed.
Yes.
But it will be a case of quo warranto. If you are not qualified to hold a post, it will be in the nature of a quo warranto rather than a mandamus or certiorari. So once it is quo warranto, delay does not come in. Because every day the man is holding the post, it's an illegality. So for quo warranto, it's like a cause of action is like as if it is day-to-day cause of action. So this delay of 22 will not make any impact. Provided he does not have B.Ed.
Provided he doesn't. Yes.
List on Monday to enable the Learned Council for the Elementary Education Department to provide the information as to whether Manik Borua, who had been allowed to be the in-charge headmaster of Balijan Girls High School in the Sonitpur district, as per the order dated 24/2/2022, has the qualification of a B.Ed degree as on 24/2/2022. Annexure 3, page 18 to the writ petition, which is a seniority list of the teachers of the school, prima facie do not reflect that Manik Borua has the qualification of a B.Ed. Depending on the answer, further orders should be considered.
Next Monday is holiday,
Monday,
Wednesday.
Wednesday.
Obliged.
Item 6 for admission. Please.
This matter is to dismissal from service, madam. Where the petitioner was, madam, as per advertisement, the
Just a-
petitioner.
I prefer sometime to have the inspection. On the last order, there was a direction to reflect the name of SSA. It
No,
has been
just a
reflected.
minute. But we asked a man to remain personally present with record. Court only says peruse the record and dispense. What did the court find out?
Pilot on the last.
So we want him back again. Personal appearance has to be back with the records. And there is a purpose why we passed that order. Purpose is, in an order of 13/7/18, it was provided that termination of Salimuddin Borbhuiya was stayed by the director. We want to take a look at the order by which director had stayed. So he had either stayed or he had not stayed. But after his appearance, possibly no one pointed out. So court also passed the order. We entertained his personal presence, dismissed it. Now we'll give the answer we have raised.
We'll get the person.
Oh, no, he has produced the order by which termination was stayed. He has produced it. So now, once the termination is stayed, what will happen?
That means he is in service, my lord.
Now, which is the impugned order?
Impugned order is Annexure 8, page 3940, my lord.
At page 39.
39.
This is order of 2005.
Yes, my lord.
Your writ petition is of 2018.
My lord, there are,
So did you challenge the 2005 order in 2018?
yes, my lord. No, my lord. It was challenged in 2000. Subsequently, it was challenged, my lord. I have annexed the order, my lord. I have filed additional affidavit whereby I have
Setting aside the order.
in the, my lord, affidavit of the
So
respondent.
yes, you have challenged the 2005 order as per your prayer. On what ground you challenge?
Challenge, my lord, because the petitioner had no knowledge about his dismissal. The petitioner's salary was stopped when he had writ petition.
No, is he attending his work every day?
My lord, till 2013, he was attending. After that, he was not allowed to sign the register. But whereas, my lord, in the other documents, in the order of allotment of work and in the list of promotion also, his name appeared.
After
So-
2017?
Yes, my lord. So I have, my lord,
Yes,
annexed all
Mr.
this-
Kaushik, what is this? This man is in service or is not in service? He cannot be both.
No, he's not in service.
If he is not in service, then why was his name included in the list for promotion?
My lord, if your lordship finds.
If Madam Chaudhary is right, what I heard,
Hello.
that after 2013, his name was included in some list for promotion.
Hello.
If a man is not in service, why did you include his name in the list for promotion?
In fact, my lord, the termination order of 2005, my lord. Your
Huh,
lordship
But
finds
that was state. We got it verified.
The,
2005 termination,
my lord,
an issue had arisen, whether it was stayed. So we called for the records, verified the records and found that it was stayed.
my lord.
Once a termination is stayed, you cannot rely upon the order of termination. That means this man is there in service.
That the termination was stayed by the interim order of a court, but and thereafter, my lord, if your lordship would kindly
No, no, no.
find the
So no,
the
I think
affidavit which
you
we
are a
filed.
little incorrect. See, take note of our order of 1110. Our order, court order. I'm reading it slowly. DO to remain present to explain why in the order dated 13/7/2018, it was provided that the order of termination of Salimuddin Borbhoya was stayed by the director. Okay.
Well.
So we call for the records whether the director had stayed or not. When the director appeared on 14/11,
Well.
order is officer has produced the order dated 17/11/2016 by which termination in respect of petitioner was stayed.
Well.
So your director has stayed it. Once your director has stayed, as on today, you can't take the plea that he is terminated.
But that stay, my lord, permissible is.
Mr.
in-
Kaushik,
my lord,
there is a variance in the views expressed by various officers of your department. You conduct your internal meeting. Tell us actually what is the position. One director said state, another secretary said not state, somebody says he's not entitled to salary, another one says he's entitled to salary.
Well,
This is what is going on.
well, because that is contrary to the, what has been stated in the affidavit.
That's why affidavit is filed by one officer. It's contrary to the view of another officer. Somebody in the department is supporting the petitioner. Somebody in the department is not supporting the petitioner.
Right.
So therefore, we are having materials and documents in both the direction. You are relying on the one in your favor, she is relying on the one in her favor. And both are by the departmental authorities.
No, let the present director file an additional affidavit to that effect.
But affidavit will not help him. If some officer of the department had given the impression to this person that the person is still in service.
Well.
Firstly, he has to be allowed to work. Secondly, he has to be paid the
the
salary.
salary.
Perhaps this is a petition for, earlier petition was there for salary.
For
Court
salary.
says you take a decision.
Right.
The impugn order says that all kind of things are said. I don't know, I read it, but could
Yes.
not understand it much what it says.
Well,
Many things have been said there.
About the selection and.
Everything is said.
There
You
was no
can
selection.
put it in a what not had been stated there. Then ultimately says you are not entitled. So challenging that order, she is again before the court. Once they are before the court, they are taking a plea that I am still serving, although I may have been terminated in 2005.
Right.
Because later on, when director had stated that termination. So is it not your internal responsibility? I know you'll refer to some documents which is in your favor. But those has to be read vis-a-vis the material we have already examined.
No, let me get the clarity.
If he is not in service, it should be clear and explicit, the man is not in service.
That
Then
has
we'll
not been-
examine by which order the man is made to be not to be in service, whether it is right or wrong. On the other hand, if he is in service, you have to give him everything. There cannot be any
there cannot
midway
be any-
course that you are in service, plus you will not get anything.
Right.
Your original was this, your original was that, you know,
Let me get the clarity.
or else if otherwise the man is in service and you feel that he should not be in service,
We'll-
draw up a proceeding, dismiss him.
Yes,
But
we'll have to. go
But
by
at
the-
least till today, he is in service. In between, you'll have to pay him something.
Let this be taken up next week. I'll get the clarity.
If you lift the veil, we know what has happened.
Yes. The
Madam
initial,
Chaudhary also knows what has
the
happened.
initial appointment,
And who are the people behind this, that is also quite apparent. But we can't go into all
Yes.
those. We have to go only what is
By
there
the
on
record.
record.
yes, by the.
From Hailakandi, this matter. That word itself is a part of the answer. But those answers cannot be the basis for the court to pass a judgment. We have to go by the law.
I'll get it.
An order dated 26/10/2005 is assailed in this writ petition, by which comma, pursuant to the court's judgment and order dated 1/4/2005 in WC 5787/1999, the petitioner was held to be not in, held to be, was held to be, have been in service without following the due procedure of law, and consequently, it stood terminated. Although the order dated 26/10/2005 is assailed in this petition, it is the stand of the petitioner that he had been allowed to work up to the year 2013. And from the year 2013, the authorities are not allowing him to report for work. A stand is also taken that subsequently, by an order of the Director of Elementary Education Assam, the order termination had been stayed. Considering the submission made, we required the District Elementary Education Officer of Hailakandi to remain present with the records for verification, for examination as to whether by any appropriate order, the order of termination of the petitioner had been stayed. Verification of the records revealed that by the order dated 17/11/2016 of the director, the order of termination of the petitioner was stayed. In other words, records reveals orders, some of which leads to a conclusion that the petitioner was in illegal service and he was terminated, so he's not entitled to anything beyond that, other than examining the order of termination dated 26/10/2005, which again would also involve an issue that the said order of 2005 has been assailed in a writ petition of the year 2018. But on the other hand, some of the materials reveal that the petitioner was allowed to continue in service up to the year 2013. Thereafter, disallowed to attend his work. There is also a order of 2016 of director staying the termination. The Secretary to the Government of Assam in the Elementary Education Department to take note of all the attending facts and circumstances, call for the entire records of the matter, and make a comprehensive statement before the court as regards the status of the service of the petitioner, that is, whether he was terminated or he is in service, and if in service, as to what he is entitled, and if he is in service, what the respondents intend to do. Respond next week.
It's directing personal affairs of the DO.
Of that, no, we are not, because that purpose is over. He had produced some order of the director. Now again, you check up whether that order is a genuine order or it's a fraudulent order. No one knows in these cases.
In that case, may I pray for the.
Because he produced with a DO, not by the director.
Well, in that case, may 4th of December.
Secretary will call everything, and if necessary, the secretary will also give a personal hearing to the petitioner and require him to produce any material as the secretary may require.
Well,
And the secretary to also confer and interact with all the departmental officers to arrive at the correct factual situation as it prevails as on today.
Item 7.
It was 7 years still.
In this
Yes,
case, 2 weeks
Mr.
time maybe.
2 weeks time for
filing reply to the affidavit.
reply. Mr. J. Islam, Land Council,
Then,
J. Oscar Land Council for the petitioner prays for 2 weeks time to file a reply affidavit.
apply.
Just after 2 weeks.
8.
You filed your affidavit.
No, 1 week time maybe.
Your name, please.
RH
R. H. Chaudhary, for whom do you appear?
number 6.
For respondent 6, prays for 2 weeks time to file affidavit.
Apply.
Just after 2 weeks.
Item 9.
For the time being, my lord. I do not see any other day. We have.
Mr. A.M. Ahmed or A. Motin? You are appearing as A.M. Ahmed or as A. Motin? A.M. Ahmed. Mr. A.M. Ahmed, learned counsel for the petitioner, makes a prayer that the matter be deferred for the time being. And on the other hand, Mr. K. Gogoi, learned counsel for the Higher Education Department, makes a prayer that the matter be adjourned. In view of the above, adjourned to be listed on.
Item 10,
Correction.
Dice data correction.
Sorry.
Dice data correction. The name of the petition.
I think you had taken up with some authorities in Delhi. What happened ultimately?
Well, on last occasion, it was the central government was directed to have inspection.
Dice data, we are told, is maintained by some NIPA under the central government. There are some corrections on the data entered to be made. NIPA says everything is over. This is where we stand, I think.
I have received a certain instruction, Lordship. After, before 2012, Lordship, it will be by the state Lordship. If Lordship, I mean, I can give the instruction to think of it.
NIPA is again throwing it back to you.
Here, my lord.
By this writ petition, certain corrections in the DISC data in respect of the petitioner is sought to be made. A stand was taken that the DISC data are maintained by an institute named NEUPA, which is a central government institution. And therefore, the authorities in the SSA have.
No, but that instruction was not in this case. I have appeared for the first time today in this case.
Record it, it's almost same thing. কি করলো? No, in another similarly situated, okay, Mr. Gogoi, you're putting in another similarly situated writ petition. A submission was made that the DISC data is maintained by an institute named NEUPA, which is an institution under the central government. And therefore, the authorities in the state SSA cannot incorporate any correction in the DISC code data. Accordingly, we require that the views of the institution NEUPA be also obtained as to whether they will be able to incorporate the necessary corrections. In response thereof, a communication dated 21/11/2023 of the Deputy Director in the Ministry of Education, bracket Shiksha Mantralaya, Department of School Education and Literacy of the Government of Assam had been produced, which is addressed to the Executive Director of SSA Assam, of SSA. Which provides the information that the DISC data are maintained by the Institute NEUPA from the year 2012 onwards. Whereas in the instant case, the correction is sought to be made in respect of a year prior to the year 2012. In other words, the Institute NEUPA had responded back that they are not the appropriate authority to incorporate the correction, and it will be the SSA who would be the appropriate authority. Mr. B. Gogoi, Land Counsel for the SSA, is praised for an adjournment to examine the matter. A copy of the communication dated 21/11/2023 of the Deputy Director of the Department of School Education and Literacy, Government of Assam, India, is kept on record.
item 12,
Lordship, I'm for the respondent number 4. Kindly matter may adjourn for today, Lordship, as my senior is suffering from sleep disc problem, so we cannot.
With your seniors. Who is your senior?
Mr. K. Borua, sir, Lordship.
K. Borua.
Yes.
Kandarpa Borua, my lord.
Huh?
Kandarpa Borua, my lord. He also rang me up, my lord. He has some problem.
Your name, madam?
P. Das, Lordship.
MSP Das appearing for respondent number
Respondent number 4, Lordship.
4 states that the arguing counsel, Mr. K. Borua, is having some medical inconvenience and therefore the matter be adjourned. Prayer out.
Item 13,
Acting Lordship, we have received instruction to file affidavit.
Mr. K. Gogoi, Higher Education Department states that the instruction is received and the affidavit will be filed within
In a 10 days period.
within 2 weeks. The prayer out just after 2 weeks.
Obliged, Lordship.
14,
It's ready, otherwise, my lord.
Who appears for the respondents?
Respondent are not
Hmm.
here.
RM Das, Social Justice and Empowerment Department. Where is Mr. Das? RM Das? Why Social Empowerment Department is required?
Because this is the school, my lord, special school, my lord, for disabled persons. And these.
Special School for Disabled Person.
These schools are.
But it will go to the division bench and court, my lord. Here, my lord, the prayer is to, my lord, modify the impugned provisions of the Assam Social Welfare Recruitment and Promotion Service Order 1995.
Division bench has.
It's not a rule, otherwise.
Division bench is demanded to single bench. Holding
Okay,
bench-
it went to division bench
Yes,
again.
demanded.
But division bench is only when statutory provisions are received. Service orders are not set at this stage. I think they are almost in the nature of executive instructions. Can you hear it today? If everybody agrees, we are ready to hear.
Contesting party are there.
Mr. Prakash, I can hear only when everybody is ready, not when one party is ready. Adjourn.
Adjournment.
Adjourn on the prayer of Mr. B. Gogoi, then counsel appearing for the
Finance here.
for the finance department, as well as the other learned counsel for the respondents.
He is appearing for the government.
To be listed again. Mr. B. Prokastos expresses certain urgency and also states that the pleadings are over and the matter can be given a final consideration. List on, so and so is paid for.
Hartari,
Sorry. File a contempt against the registry.
No, he is a newly appointed.
Sorry.
He is a newly appointed standing counsel. The petitioner will at least intimate him by serving
Yes.
it. That may be reflected.
That's of course.
registered. Item 15,
And here 2 weeks time to file it.
Mr. Ganesh Pegula and counsel for the elementary education place for 2 weeks time to file affidavit.
16 and 17,
Petitioner, my lord, he was allowed to.
No, Mr. Decca, I'm ready to hear you, provided the matter is, we can hear it. Can you hear Mr. Gugui?
See any other day, Lordship. Today, one affidavit is not in the record. 2 affidavit we have filed.
Next
Next
week,
week,
next week.
Lordship.
Adjourn the prayer, Mr. K. Gugui, London Higher Education Department, to be listed again on.
Right.
Some-
Deeply obliged.
sorry to request. Item 18,
This, my lord, compassionate appointment,
Sorry, compassionate,
my lord,
please before DLC.
DLC, recommended SLC research.
Where is the DLC? Where is the SLC? Page number?
DLC page 54,
DLC, page 54.
serial number 11,
This thing.
Debabrati Day,
Debabrati Day.
and
Debabrati Day, did I hear this matter earlier?
yes, my lord.
Name appears to be a little familiar.
My lord, here.
And where is SLC?
SLC.
Page 61.
61. 61. That's room number 6.
Applied after 1 year, rejected due to non-availability of norm. What kind of norm?
That my lord. Applied after 1 year.
No, after 1 year. That is after 1 year. That's an observation. You did not reject for that reason. He is rejected due to non-availability of norm as per OM dated 1/6. Which norm? Had you rejected straight away, after 1 year we are rejecting, we'll take that is the reason. But that is only an observation. The reason is he does not have norm.
But what?
Which norm he does not have, we'll examine it, whether he has or not. Mhm.
So at the point of date, the petitioner was minor.
No, but they're stating that evaluator norm, so we set aside, send it back. It's a vague order, non-availability of norms, unless you specify which norm is not available and why it is not available.
Round of election required to display.
And regarding 1 year minor Khadim, follow Khadim, do the need to. Heard Mr. N. Hockland, counsel for the petitioners.
For 2 and 3.
Mhm.
And for respondent.
Mr. Ganesh Pegu for the Elementary Education Department, Mr. P. Sharma for Chief Secretary and Deputy Commissioner, Kachar. The father of the petitioner, Ganesh Chandra Dev, was the head teacher of Ras Bihari Government Junior Basic School, Rangpur, in the Kachar district. Died in harness on 11/11/2016, and on his death, the petitioner submitted an application for compassionate appointment. When did you submit?
My lord, page 52
Page-
to 2022.
On 2/2/2022. At the time when the deceased died, admittedly, the petitioner was a minor. And later on, upon attaining majority and also the necessary qualification, he made the application in the year 2022. The said application was considered by the DLC of Kachar district in its meeting of
5/3/2022.
5
3/2022, page 50.
53.
50.
No, it held on 2/2/2022. In its meeting of 2/2/2022, and upon considering the availability of vacancy as well as the qualification of the petitioner, he was recommended for compassionate appointment against the post of assistant teacher in a LP school. When the recommendation of the DLC was placed before the SLC, the SLC in its meeting of 26/8/2022 rejected the recommendation made in favor by providing as extracted, page 61 of DDO. A reading of the order of the SLC makes it discernible that firstly, the SLC made an observation that the application of the petitioner was made after 1 year of the death of the deceased. But the reason for rejection is stated to be non-availability of norms as per OM dated 1/6/2015. The order of the SLC appears to be an unreasoned order, as nothing is stated as to why the SLC is of the view that the petitioner do not satisfy any norms provided under the OM dated 1/6/2015. Any unreasoned order would have to be considered to be an arbitrary order under the law and would invite being set aside. As regards the other reason, or as the observation that the petitioner applied 1 year, we have already noted that the deceased died in the year 2016 and the application was made in the year 2022, with an explanation that at the time of death, the petitioner was a minor, and later on upon attaining majority, he obtained the necessary qualification and had made the application for compassionate appointment. The law in this respect has been settled by the Honorable Supreme Court in its judgment rendered in Khadim reported in so and so, and the proposition thereof would prevail as regards the application made by a minor, which would mean that an application of a person who was a minor at the date of death cannot be rejected outright merely because it was made after 1 year of the death. Matter upon setting aside the rejection by the SLC immediately, the matter stand remanded back to the SLC to be placed in its next available meeting to consider the recommendation made by the DLC in favor of the petitioner on its true merit and not on other extraneous technical grounds as sought to be made out earlier.
Thank you. Item 19,
He's a very, Mr. Saikia, his qualification is very nice. He obtained some 70 or 80% marks. He'll get a very good teacher also. Instead of giving it to some those 30%, 40% category, this man will be a very good teacher. And we see no reason why he's not entitled. Unless you give reason that in the meantime, the financial status of the family had gone up so much that he does not deserve any more compassionate appointment.
May I please, Please, the Lordship, on 12/10/2023, my lord, the secondary education department has got time to file their detailed affidavit, my lord. Earlier,
Sorry?
They have got time to file their affidavit, my lord.
They have filed, not filed.
My earlier one file, my lord, it is not in details, my lord. They
Okay,
have
Mr. Mujumdar, you want to file detailed affidavit?
a little more time, my lord.
Uh,
A little more time, which time?
Although an affidavit was filed earlier, but the respondent authorities intend to file a more detailed affidavit for which time was granted on an earlier occasion, for which time was granted earlier. As the affidavit not filed, further time is sought for by Mr. R. Mojumdar, Land Council for the secondary education.
Secondary.
Oh.
My lord,
For filing the affidavit, pray allowed, just after 2 weeks for the affidavit.
well, a similar application is pending, my lord. Can I take this matter along with me,
We don't know.
my lord?
We find that prayer a little
My-
difficult.
It is not listed today.
We'll decide this matter. Other one will follow if it is similar.
My-
Why do you have to join everything together?
Obliged.
If the it can be decided together if the question of law is same. Okay. If I decide this petition, the other one will follow. You don't have to join all the petitions.
My lord, I can. Obliged, my lord.
21,
And please, Lordship, it's a matter regarding Lordship. Because shortage of post Lordship, it was not for.
Sorry.
Yes. Page 27.
No, merit we understand. Today what we do? Prayed for the land cost state government for the 3 year render filing of, have you filed the affidavit? Did you file the affidavit? Last order, 3 weeks granted to the state to file affidavit.
My lord, there is dispute pending before this, my lord. District education elementary person. He has not placed before the, my lord, DNC.
We don't know.
My lord.
Last order is
My lord.
Land Council for the state government prays for further 3 weeks time to file affidavit. Have you filed or you have not filed? Do you want to file or you don't want to file?
In fact, we not required to fetch for matter have to.
You are
place
not
matter.
required to be filed. Okay, we'll hear you without your affidavit. Yes, what is the matter?
Page 27, Lordship.
What is 27?
The official note, Lordship.
Hmm,
Official letter, Lordship.
official
Last
letter.
para, it may be mentioned that in LP school presently no grade 4 post is vacant
Just a
under
minute.
deputy inspector.
Mr. Alamgir,
It is not the correct, Lord.
Mr. Alamgir, how do you expect us to understand the matter? Somewhere in the middle of the thing, you just catch hold of one document and say that this is not correct. Who is the petitioner? What is his case? What the legal right? Which right has been violated? By whom it is violated? In what manner it is violated? Only then we'll understand document suddenly from the between. Shall not produce the DLC petition application. Some compassionate appointment. Was it placed before DLC or not placed?
They are not placed, Lord.
Not placed.
Placed.
Get it placed. Give the facts. Who is the father, when he died, where he worked, when he made the application? Next second. Give the facts to the secretary. We'll pass the order.
Other-
Item 25, who is appearing?
Item 25 for orders.
Please, your Lordship. Lordship, maybe time being, your Lordship. Senior is coming.
Senior is coming. Mhm.
Item 26.
Please, my lord. My lord, the conducting council KP Bhatta is on legs, my lord. Password for a timing, please.
I just, on the last occasion, my lord, I remember, the only issue which was raised by the friend was that, the supply code for the competition of the theft of electricity.
Mr. Pathak appeared in the
Right.
other side. Some those clause 4.2.24 and 4, all those that matter. Huh.
Section,
Huh.
section 27. But my lord, my other friend had not placed it that the supply code, that conditions were amended. And I think he has taken the old book.
Okay, in the meantime, it is that provision is not available on record.
So that now in conformity with section 127, so the entire argument is.
I understand.
My lord, Mr. Pathak is on legs in court 17, he's in the midst of a hearing. It's requested that your lordship may be pleased to defer the matter for
So
a time
it's
being.
okay, his request is good. Just take note from Mr. Kejriwal
Well.
that Mr. Pathak relied upon some particular clause
My lord,
to substantiate his case.
Well.
Now it is stated that that's a part of the old regulation. As per the present regulation in force, that clause is not there. So
I'll take note.
take note of the information, and possibly Mr. Pathak will need some time to prepare his matter. We fix it up on Mr. Saraf, Dr. Saraf,
My lord.
we fix it next Thursday. We put it on record, your submission, that that particular clause relied upon is no longer exist in the thing. And Mr. Pathak to take note of that aspect,
my lord,
and you come prepare on the next day. Otherwise, again, he'll take time today.
my lord, my.
Dr. Ashok Saraf, and counsel, senior counsel for the petitioner, has stated that clause 4.2.4. Mr. Kejriwal, what is that clause?
Sir,
5.8.
That 5.8, 5.8.4.4 of the, what is it called? That one?
Supply code.
Of the supply code, which was relied upon by Mr. K.P. Pathak, Land Counsel for the APDCL, to substantiate his case, had in the meantime been amended in the statute books. And as per the supply code, which is in vogue at present, do not contain the state clause. Mr. Pathak is required to take note of the aforesaid submission and examine the matter and make further submission on the next returnable date. List on.
Next Thursday.
Please, pray.
Next Thursday, we'll close this matter. We have heard it enough.
No, like,
27 and 28 for hearing.
Your Lordship, my senior, Mr. H. Buragohain, is on legs.
Your senior is
H. Buragohain,
H. Buragohain. He's on legs.
is on legs at good seven.
What are you to do? Adjourn?
Yes, sir.
Adjourn
Not for adjourn, the matter may be taken after some time.
after some time.
29,
My lord, in this matter, Greenpeg will appear, my lord.
Who will appear?
Greenpeg will appear, my lord.
He is having difficulty today. It stated that Mr. Girin Pegul, an additional Senegal advocate, would appear in the matter, and the learned counsel is having some inconvenience today. List again, adjourn to be listed again on.
please take 30. 30 and 31.
But I'm looking for, number 30, my lord. This matter relates to selection appointment of my lord. Assistant
Sunita
Professor-
Devi and Dolly Talukdar. Both are tied up together.
Yes, my lord. In this petition, I am for the petition.
You are appearing.
Yes, my lord.
Mr. Abedin earlier appeared or what? He's sitting behind us and smiling.
And in 31, I am the.
It's something like in the nature of a cross case,
Yes, my lord. My lord, that is.
because Mr. Kakoti is a petitioner in one matter and he's for the respondent in the other.
In one case, Lordship, I am for respondent number 7.
And
In other case, I'm for the read
it's
petition.
a cross case. In the nature of a cross case.
It's not a cross case, Lordship, that impugn order has been challenged by petition as well as by me on there are two defined parts.
Two different grounds,
Lordship,
on two different grounds.
one time is
The legal rights violated are independent legal rights violated.
Lordship.
You are challenging for your violation and
Lordship.
Madam is challenging for
Her-
their
her-
violation.
That is the-
Okay, can you hear it today?
Lordship.
Can you hear it today?
Yeah,
Yes,
If everybody is ready, we'll hear it.
Lordship.
If everybody is ready, we can hear it.
I'm ready in that case.
And Mr. Gogoi, are you ready? But once I start, I won't like to adjourn it again. Take your call in the beginning. If I can hear, I'm ready to hear.
My lord, this is a long pending matter, my lord, since 2018.
Because after hearing for half an hour, adjourning is a wastage of time for everybody.
Lordship.
So either we hear and finish it off or we,
Your Lordship, please.
no, we are open. We have no difficulty at all.
Lordship.
I am here till 4:30.
That matter is proceeded.
Should we start the hearing?
Lordship will then this is the petitioner for the first case. Then initiate hearing.
Mr. Gogoi? Shall we start? I don't know. If you are hesitant, we adjourn, fix a date. If you are ready, we hear it.
We are ready, my lord.
Otherwise, Lordship, I have to produce.
But one aspect, we'll be disinclined to adjourn it once the hearing starts.
What is necessary in the midway?
I don't know.
Then Lordship,
We, before I start hearing, we can't say whether record will be necessary or it will not be necessary.
then they.
So you want to produce the records. Mr. K. Gogoi, Lanka Higher Education Department seeks for an adjournment for production of the records involved in the records pertaining to the dispute involved in the writ petitions. But on the other hand, MSSB Chaudhary, Land Counsel for the petitioner in WBC 158/2017 and Mr. R.P. Kakoti, Learned Senior Counsel for the petitioner in WBC 5227/2017 are both ready to carry forward the hearing. List on
First day,
Start date, maybe
5th December.
5th December.
yes.
Item 32,
Get the record
Like-
if you see.
Lordship.
Even if you don't need it, bring it.
We have filed affidavit in the media.
Mr. Gogoi,
Lordship,
even if you don't need the record, bring it.
Lordship,
If you need, we'll examine. If you don't need,
Lordship.
you can take it back.
Lordship.
Obliged.
Thank you. Respond for hearing of the matter on the claim of pensionary benefit. Responded to use entire records pertaining to issue taking voluntary retirement as well as. You have the records, Mr. Talukdar? You have the records?
What was called for the. for- the
Who-
direction of this-
Who
the
will produce the record?
department.
Mhm.
Pension paper has not been sent from the.
I know
district, my lord.
two issues are there. One, petitioner had taken voluntary retirement. That is your case. Possibly they are disputing it. This is number one. And two, the date on which graduate scale of pay was given to the petitioner.
This
Now,
will be
who will produce
Secondary
it?
department.
Who appears? Mr. SMT, it stated by the order of 12/9/2023, the entire records pertaining to the petitioner taking voluntary retirement as well as the records containing the date from which he was given graduate scale of pay was required to be produced before the court. Mr. SMT Chisti, Learned Counsel for the Secondary Education Department, prays for some further time for production of the records. List on.
Let me kindly click, my lord. I
So I think-
retired on 2016. Nothing has been disbursed. Lordship.
1st December. Item 33.
You take note of it today. নামটি দিব কৈ দিব Yes, madam.
Lordship, the matter here pertains to regulation of services of the petitioner, Lordship.
Regularization.
Lordship, she is working in a post of zoology, Lordship, in the Bilasipara College. As an assistant professor.
Mr. Gogoi, same question. Ready?
Also, we have filed affidavit, Lord. In the affidavit.
No,
we
that
have-
I know. Are you ready for the complete hearing?
Otherwise, we are ready, but in the affidavit it does not reflect the number of the student. Our ground is that, Lordship, minimum required student is not there.
Of that particular subject, the
particular
minimum student, the petition does not meet that.
Lordship. So she is
So
not,
not entitled to be regularized.
but Lordship, the student has number of student not.
Then bring the records.
Lordship, Lordship.
So one document we have annexed, let the record be, Lordship, we have. the
No,
annex-
you have a next, but they will have to edit the document.
Lordship, Lordship.
Otherwise, Lordship, we have. filed
The petitioner, who is a lecturer in
Zoology, Lordship.
zoology in the Bilasipara College, seeks for regularization of service. Mr. K. Gogoi, Learned Counsel for the Higher Education Department, submits that in order to be eligible for regularization, there is a requirement of a minimum number of students attending the particular subject in the given college. The affidavit of the respondents shows that in respect of subject zoology in the Bilasipara College, the number of required students were not available in order to enable the petitioner to claim a right to be regularized,
Provincialized.
to be provincialized. Provincialized voter is regular. No. In view of the above, the relevant records which may show the number of students in the subject zoology in Bilasipara College of the relevant period of time be produced before the court. List on so and so.
4th December. Item 34 to 38 with personal appearance.
This is that matter, my lord, where your lordship,
Mhm.
lordship wanted to know from the PO and the headmaster,
Mhm, mhm.
how the petitioner
Just
was.
a minute. Let me refresh myself
Fine.
by reading the.
Sorry.
Have you gone through the records?
My lord,
For whom do you appear, Mr. Saikia?
Private respondent number 6.
Private
He was,
respondent.
alarm service was ready.
the private respondent, my lord, who her appointment was as an additional teacher. The headmaster says that she was teaching Assamese language.
From which year?
Which year, my lord, he. From the date of her appointment, 2008. And therefore.
No. How do we will we authenticate that statement?
That, my lord,
Statement is a good statement.
Yeah.
But how will you authenticate it?
my lord. He says that the
See,
ties that.
other man is a Hindi teacher.
Right.
One question will remain whether Hindi is
Hindi
included as language or
as a
not. We'll have to decide that
Yes,
separately. That issue remains.
Right.
Other one, this person that is teaching language since her initial appointment, in what manner we conclude that?
my lord.
What are the materials other than the statement?
My lord, the headmaster
Therefore, we ask to complete records.
completed. The DO,
I never asked headmaster to come and make a statement.
my lord.
Produce the records. And who is the respondent?
He has brought the dice data, my lord, where the.
Dice data is filled up as per his information. That's of no use. Unless challenged,
Well,
if challenged, dice data has no value.
And dice that I'm also what which he has brought, my lord. In this, I find, my lord, there is a handwritten correction which has been done by him. The main subject taught English. And in appointment of the subject, it has been shown all subject
This is ME school.
MSc.
In which year the respondent 6 was appointed?
Respondent number 6 was appointed in 2008,
2008.
19/2008. Date of
This attendance is taken in the beginning of the day or it is taken in every class?
In the beginning of the.
Beginning. So that will not help you. Show us one result sheet of that relevant period, 2009, 10, etc.
Right.
In respect of Assamese subject, which had been signed by this respondent number 6. তেওঁ যদি শুনক এইফালে হওক তেওঁ যদি ইংৰাজী বা অসমীয়া পঢ়াইছে আপোনালোকেতো পৰীক্ষা পাতে অসমীয়া পৰীক্ষাটো পাতিবই বছৰৰ মূৰত তাতে সহি কৰা থাকিব শিক্ষকজনক সেইখন পেপাৰৰ কোনে সহি কৰিছে দেখাই দিয়ক আমি সেইটোৰ পৰা ওলাব নহয় কি কৈছে
The respondent number 6 has.
attendance register নালাগে সেইবোৰ এখন ৰিজাল্ট শীট 2009 ইংৰাজী সাবজেক্টৰ বা অসমীয়া সাবজেক্টত কোনে সাইন কৰিছে সেইখন আমি দেখাই দিয়ক যদি তেখেতে অসমীয়া পঢ়াইছিল অসমীয়া ৰিজাল্ট শীটখন তেওঁ সাইন কৰিব নহলে আপোনাৰ স্কুল বন্ধ কৰি দিম আৰু একো যদি নাৰাখে কিয় স্কুল চলাই আছে will directly directed to close this school because they are not maintaining any record. School এখন তো আপোনাৰ নিজৰ ঘৰৰ সম্পত্তি নহয় যিমান যে তাকে কৰি থাকিব যেতে তেতে
He says that the records are there. He has written not.
So who asked him not to come with the records? I asked, we impose a cost of 10,000 on this headmaster for not coming with the records. List again. Answer is, our order is very specific.
My lord.
Complete records which may indicate.
Right.
That word is broad enough to say any document, any material from which you substantiate the issue. So who asked him not to come with the records?
ৰেকৰ্ড কৈছে নহয় গোটেই কোনে কি পঢ়ায় আপুনি জনোৱা নাই নেকি? The DO was informed. We informed the DO.
But DO says he told him.
He told.
The headmaster in your name, please. Naam kya apna? The headmaster of Motabari ME Madrasa is present before the court as required by the order 21/11/2023. The order requires the headmaster to remain present before the court with complete records which may indicate as to why the respondent number 6, although appointed as assistant teacher, had been categorized as language teacher. The headmaster makes a statement that from the date of initial appointment as assistant teacher, the respondent number 6 had been entrusted with the duty of being a teacher in the Assamese subject. Apart from the oral statement of the headmaster, no further record is brought to substantiate the same. It appears that the headmaster is not duly complying with her earlier order to produce the complete records. Headmaster to again remain present on the next returnable date with the complete records. For having not brought the records today, a cost of 5,000 be paid by the headmaster.
When the earlier order, called settlement of the records. So
First, let us settle this issue and then we'll go to the other issue.
that ought to have been 350, not 351. 350 was filed by the deputy. So today, fairly comfortable record of 350 of 2020.
350 means? Okay, some. It should be 350. 350. In modification of our earlier order, dated.
230.
Where is that calling for another report?
No. Well, may I clarify this? With Lordship, there was an issue that regarding the Hindi issue, my lord. I pointed out, my lord, that there is one repetition.
Okay, you are not concerned with that for the time being. That is a separate issue.
That is a separate issue. In
See,
that repetition, we filed a detailed affidavit.
If the respondent number 6 goes through the first phase, that she is a language teacher from the inception.
Right.
Second issue, we did not go into it because even if we consider it as a language, the other one will be senior. But if the respondent number 6 is not a language teacher, then only the next issue will come. We'll decide that separately.
Right. Well,
Why these simple things are not done, I don't know. Then we face the consequence.
Right.
Because repeatedly we are finding the headmasters, they come with a very bold appearance that yes, I'll tackle the court of whatever way it is required to be done. But
and specifically, my lord, that was.
when it was told,
In fact, I communicated that the record to show.
so that
this
the person was teaching Assamese language, and we are giving it's a wide enough a word order, any document which you feel.
I said,
Suppose today he would have come with a document that with this I want to say, we are not accepting the document, that is okay. He thought it will be a good document, we feel it is not a good document. But don't bring anything. You're wasting everybody's time,
Yes.
nothing else.
well,
No, when he appears on Tuesday, he'll first deposit the cost in the list income.
whether the DO personally attend.
DO possibly now it is not required.
I'll return the
Yes, if necessary, we'll have him again.
Well.
The presence of the district eliminator stands dispensed.
Hello.
আৰু আপুনি অলপ চাব কি হৈ থাকে এইবোৰ স্কুলবোৰত
28 তাৰিখ।
এই provincialization নামত যিখিনি যিমান গণ্ডগোল একোটো নাই। We indicated you the other day why is all these are happening.
Change কৰিব নেকি? Change. Item 39.
Thirty-nine.
39.
Yes.
Item 39.
আৰু এইটো মোৰ অৰ্ডাৰো আছিল নেকি এটা এইটোৱে নেকি $95. Yes, what is the submission?
Presently, I am discharging the planning and statistical officer's duty in Nagaon. So I may be a job in Nagaon. My,
Why? Why?
I have.
This is a prayer, not your submission.
Recently, I joined as a statistical assistant and promoted to the post of planning and statistical officer in 2022. My lord, I have problem. That's why I filed representation. Page number 23, my lord. Page number 23 is my promotional order, my lord. I have enclosed page number 24, my son's, my lord, record, where he is 50% disabled child. My lord. Submitted the representation, my lord. Page number 25.
Due to intellectual disability. Where does your son stay? Where does your son reside?
My lord, it is me. Nagaon. My wife also gone for
No, that I have noticed. Your wife is. Earlier, where were you posted? Golaghat.
Nagaon. I was.
Then if you are in Nagaon, remain in Nagaon. Where before the court then?
I was promoted in 2022 and posted in Golaghat, my lord.
Okay, after promotion, you were posted in Golaghat,
Yes. But,
but originally Nagaon.
yes,
Now you are allowed to discharge your duty from Nagaon. You say there is a vacant post in Nagaon, and you want to be adjusted against that, transferred against that vacant post.
this post is vacant from 1/5/2023. Earlier incumbent is retired, my lord. And presently I am discharging.
The post became vacant on 23. The petitioner was promoted to the post of.
No,
planning
no,
and safety.
earlier what has happened because a person has to be
He
promoted.
says, my lord, that
There
he
is
has
no
been-
post, so posted in Golaghat.
Well,
But
no.
as of now, as a post is available in Nagaon, this man had been in Nagaon since before. So he's having a child with intellectual disability. Naturally, the care that the father has to give, plus the medical attention, is more suitable at Nagaon, because from before they are having that thing. In between, he had to go to Golaghat, no post is there.
Well,
Now post is available.
he never went to Golaghat pursuant to that promotion. He says that he was allowed.
But we don't take it to be a case of indiscipline in this case, because when a claim is made under the Disabilities Act, it is a right of the child. It is not the right of the employee to be posted here or posted there. It's a right of the child. So the child has a right under the law to have his caregiver, that is his father, along with him. Child is all along at Nagaon. So if there is a convenience available of a post being available at Nagaon, considering the legal right of the child, you consider this representation.
Observed it and
We'll observe it that this is not a case where the legal right of a government employee is being determined, where to be posted, or the convenience of the government employee. We are determining it from the point of view of the legal right of the disabled child to have his father with him. I think that is the purpose of the law.
in fact, the Supreme Court also has.
It should be. I think that's yes.
I may be observed in the Nagaon.
Why?
The vacant post.
Why? The summation is not coming from the side of the petitioner.
Because my son is 50% disabled child and my wife also aged woman, my lord. He can't take care, she can't take care of him.
So if you bring in a wife, the case will be dismissed. Because again, it will be self-contradictory with the right of the disabled child under the disabled law. Your wife doesn't have a legal right to have the husband because she will undergo a surgery. That right is not available.
But presently I am discharging my duty as a planning and statistical officer in Nagaon, my lord. This post is vacant. They have verbally directed me, but they have not.
Heard M.S. Das, Land Counsel for the petitioner, also heard Mr. B. Kothik, Land Counsel for the respondents in the Secondary Education Department. The petitioner, Padmakanto Bora, was initially serving as Before promotion, what was the post he was holding?
Statistical assistant.
Statistical assistant.
Was initially serving as a statistical assistant in the office of the Inspector of Schools, Nagaon. Where is the order of promotion?
Page 23.
23.
23.
Page number 2.
By the order of the Director of Secondary Education Assam dated 22/7/2022, the petitioner was promoted to the post of Planning and Statistical Officer, and upon promotion was posted in the office of the Inspector of School, Golaghat. It is stated that as on 22/7/2022, when the petitioner was promoted to the post of Planning and Statistical Officer, no vacant post of Planning and Statistical Officer was available at Nagaon. And accordingly, for exigencies of service, the petitioner was required to be posted at Golaghat. But it is rather unfortunate that the petitioner is also the father of a specially able child, who is presently stated to be aged about 21 years. No. Yeah, what is the age of this boy? Who is presently stated to be about 16 years.
16.
The certificate of the Joint Director of Health Services, Nagaon, is available on record, wherein the son of the petitioner, Prasudya Bora, had been certified to be suffering from 50% permanent disability due to intellectual disability, bracket moderate. As per the certificate of disability, it is apparent that the son of the petitioner, Prachurja Bora, is a specially able child who requires special care and attention of the petitioner as a father. Upon promotion, as the petitioner was posted at Golaghat, promotion at planning study, posted Golaghat, the child of the petitioner was inconvenienced to the extent that the caregiver father, caregiver father had to be separated from him for his service conditions. In the circumstance, the respondents by another order dated, where he was adjusted, you say, adjusted in Nagaon.
There is no order.
The respondents had, by taking a sympathetic view, had allowed the petitioner to be attached to the office of the Inspector of School, Nagaon. Full stop. It is stated that in the meantime, one post of Planning and Statistical Officer in the office of the Inspector of School, Nagaon, has fallen vacant. And in the circumstance, the petitioner has made an representation dated 5/8/2022. Where is the representation?
29/5/2020, page 26.
29/5/2023, making a prayer that he may be transferred and adjusted in the vacant post, which is available of a planning officer at Nagaon. It is also stated that at present, the post of Planning and Statistical Officer Nagaon is vacant and no one is occupying the post. Although the petitioner had raised certain other assertions in the representation that his wife is also suffering from certain medical ailment and requires surgery, comma, for the purpose of determining the present writ petition, we are not required to go into such assertions. And full stop. But what we take note is that the petitioner is the father and caregiver of a specially able child who is certified to be suffering from 50% disability with intellectual disability. Right to this Disability Act, which section? Any idea? We did not go through both the acts.
Specifically, there is no.
It's not there.
specific-
The right of a specially able child to have the comfort of the caregiver father had been recognized by the Government of India in the Ministry of Personnel, Public Grievances and Pensions in their office memorandum dated 6/6/2014, wherein it has been provided that there has been a demand that a government employee who is a caregiver of a disabled child may not have to suffer due to displacement by means of routine transfer, rotational transfer, etc. And considering the matter in its entirety, the Government of India in the Ministry of Personnel, Public Grievances and Pensions in their office memorandum dated 6/6/2014 had provided that in the case where a government employee would be a caregiver of a specially able stroke disabled child, comma, such employees should not be subjected to any displacement in course of its employment, which may have a bearing on the systemic rehabilitation of the disabled child. In the instant case, it is taken note that the specially able child of the petitioner is presently aged about 16 years, and he has been provided the systematic rehabilitation under the facilities available at Nagaon, inasmuch as prior to the promotion and transfer, the petitioner was all along posted at Nagaon. In the circumstance, a conclusion could be arrived that a specially able child of the petitioner, namely Projuzio Boranegi, has a legal right under the law of disability to have the benefit of his caregiver father to be with him without any resultant displacement of the specially able child. In other words, to provide a place of posting to the petitioner at Nagaon, we are of the view that it is a legal right of the specially able child, Projuzio Bora, to have his caregiver father near him at Nagaon, so that his systematic rehabilitation process is not hampered. We are clarifying it to the aspect that this is not a legal right of the government employee to have a place of posting of his choice to be near the specially able child. But on the other hand, it is a legal right of the specially able child to have the caregiver father near him so that his systematic rehabilitation process is not hampered. From such point of view, there is a requirement under the law of the respondents to give a due consideration to the representation dated 29/5/2023 of the petitioner Padmakanta Bora, requesting that he be given a place of posting as the Planning and Statistical Officer at Nagaon. Full stop. In doing, we also take note that even the respondents or any other government employee may not be inconvenienced if the petitioner is given a place of posting at Nagaon, in as much as the post of planning staff at Nagaon is presently vacant. Where, in any view of the matter, for administrative exigency, the departmental authorities would transfer and post some employee at Nagaon. Having determined as above, we direct the Director of Secondary Education Assam to give a due consideration to the representation of the petitioner dated 29/9/2023 by further providing that in doing so, the directors shall take note of the legal right of the disabled child of the petitioner Pradyuta Bora under the law of disability and do the needful. And in doing so, the director shall not consider their representation to be a regulation representation of an employee seeking transfer or posting at a given particular place. The written order be passed by the director within a period of 15 days from the date of receipt of the certified copy of the order.
Item 41 for admission.
May please, Lordship. In this case, Lordship, already we have steps taken as per last order, Lordship. That's one of
Steps taken?
step already taken, Lordship.
Has a notice been served?
Four has
Have you
already-
checked up the office note?
Already appeared, but four has already appeared.
Acha, 4 has appeared.
Madam.
Who appeared? You, Mr. M.U. Mandal, Land
We
Council.
have for 5 minutes.
Who is for 4?
A Wahab. Madam.
Huh?
On A Wahab, Abdul Wahab.
Where is Abdul Wahab? It stated
name
that
is
Mr.
shown.
A. Wahab Land Council had entered appearance for the respondent 4, but Mr. Wahab has not appeared before the court this again. What to do?
Reply, Lordship, also will file, Lordship.
Sorry,
Every has been filed by respondent 5. We will file reply, Lordship.
find it.
Problem.
Petitioner may file a reply affidavit to the affidavits of respondent.
Production list item 1.
Date may be given, but date
Date.
obliged.
Yes, Mr. Doctor.
My lord, very small submission would be. This matter, my lord, the interim order is as on today. So my lord, we have filed another new application challenging the appointment order of respondent number 8. So therefore, my lord, that matter.
You
was
filed a
also-
new affidavit.
Affidavit we have filed as well as a new.
No, you
writ
said no,
petition.
that to file a separate affidavit in support of the writ
That we
petition.
have filed.
That is filed.
Now, another application, writ petition we have filed, it was supposed to be listed today. He doesn't come today. So my prayer would be, my lord, you lordship take both the matters on 28th of this month.
On the prayer, Mr. S. Total and senior counsel for the petitioner, list on so and so along with such.
28. In the meantime, interim order.
The interim order passed earlier to continue till the.
28.
Let it be in the first week of December.
A date.
15 December,
15. 15 December.
5th, my lord.
15.
Can it be on 5th?
Eight.
8th, my lord.
8.
Because of their. Lord. Yes.
In the meantime, the respondents may file their affidavit if so advised,
Mother.
so that we can hear the matter the next day.
Right.
যিকেইটা আছে লৈ লওঁ সেইটোতো অহা নাই, সেইটোতো 2 বুলি ক'লেতো বাকীকেইটা মাতি দিওঁ।
Obliged.
Timing item 4.
Yes, Mr. Das.
My lord. Here, my lord, I have also the instruction that the impugn order in the meantime, the respondents, my lord,
You
modified.
to inform why order they passed allowing the blockade to be the.
And my lord, by order to the 1611, my lord.
Who appears for the DO? Elementary education. Mr. Tobildar, elementary education.
In the meantime, they have issued another order, my lord. That the impugn order they have modified and allowed us.
Then you have to file a new writ petition. We cannot prolong this writ petition for the
Yes.
other order.
Well, they have allowed us to continue. Yes, sir.
Okay. We passed some interim order on a 1610.
My lord.
So today what we should do?
I know we have already allowed a petition on it today.
Understand, but today what we are required to do?
Let me dispose of our minor, allow some time to file it.
And on the prayer MSS, Tutorial and Council for the Elementary Education Department, 2 weeks allowed to file the affidavit. It is stated that pursuant to our interim order dated 16/10/2023, the writ petition had been allowed to
Work as headmaster.
work as the headmaster. The said factual statement made is taken on record.
Obliged.
Item 25.
Sorry, my lord, I could not.
May I please lordship? My lord, at the very beginning, when I humbly have submitted that, my lord, on 8/11/2023, lordship passed an order, my lord, with the objection that it is also admitted position of the railway that ticket was procured by the DGs on 14/8/2012, which is the date of accident itself. My lord, here, I already submitted, my lord, that on the after death, during the investigation, they are recovered 2 outdated tickets from the possession of the DG.
Two?
Police, Palasta Police Station, GRP.
No, we'll hear you on that.
My lord. So he.
But this statement, we are saying admitted because it is a statement we have taken from the report of the DRM. This line is available in the report of the DRM. DRM is a officer of the railways. So it is the admitted position of the railways that it was there. Nothing wrong with that.
It is procured by the DGs. It is not procured by the DGs, my lord. It is recovered by the railway police.
If you have recovered from the deceased, it must have been procured by the deceased. How can the ticket can be recovered from the deceased unless the deceased has procured that ticket?
Yes.
He may have procured from your counter, he may procure from another man, he may procure from a tout, he may have procured from an illegal source, but he had procured.
But the date,
So where is the
date is.
Madam Chakraborty, forget about these trivial issues. come to the real issue and argue your matter.
I submitted that. my lord.
And we are not at all interested to go into all these petty trivial matters, issues.
So, my lord, in my affidavit, in my appeal, my lord, I have submitted by the inquest report case diary.
So you are awarded 4 lakhs by the tribunal.
Yes, we have been awarded.
You are challenging it.
Yeah.
Yes,
On
my
what
lord.
ground?
My lord, it's on the ground that there's no valid ticket found in the possession of the deceased, my lord.
No, your ground is valid ticket was not found when the inquest was made.
Yes, my lord.
Okay. And it is not a case that the valid tickets were not found at all. Valid tickets were found by the police who had taken over the matter of death caused to the person. When a man dies within the railway precincts, 2 authorities have simultaneous jurisdiction to inquire.
Yes.
It being a case of death under the CRPC by the police.
Yes.
The death being called to be described by the expression untoward incident by the railway under the Railway Act, it is also investigated by the Railway Protection Police.
Yes.
There is a rule 17 something of that procedure, how you investigate.
Yes.
As 2 parallel proceedings, investigation are going by 2 different organizations. Rule 17, in order to meet the claim of any compensation for untoward incident, the Railway Protection Force can procure the records from the regular police. And that record may be used as their defense for a claim. So now what is your ground? In the background of this position of law, what is your ground? Why should he interfere?
My lord,
Where did the trial committed an illegality? Point out.
my lord, in my ground, my lord. First, my lord, will kindly observe, peruse this judgment at page 13 of my memo appeal.
Who perused?
Lord, I am paying lordship to pay.
Oh, you are asking the court to peruse the judgment.
No, my lord. I am paying to look at this matter, my lord.
You want the court to look at what?
No, my lord, go to the judgment, my lord.
Judgment of the tribunal.
Yes, my lord.
Okay, which page?
At page 13.
Page 13. See, in appeal, you will have to interfere. You will have to point out an illegality committed by the original court.
Yes,
Point out.
my lord. Yes, my
If you can point out, we'll definitely hear you.
Ground, my lord. My lord, here, first of all, my lord.
Now,
that-
which
that
page?
Ground I have not.
No,
taken.
you want us to read the order. Which page?
My lord, page 13, my lord.
13. Okay.
First of all, Srimati Gangaram is the applicant. But in this judgment is written that application is filed under section 16 of the Railway Claim Tribunal Act for compensation on account of death of one Srimati Gangaram.
Who died actually?
Eh?
Actually, who died?
Sanjay Kumar Roy.
So don't worry, we'll correct it. This will not make the order invalid.
My lord, as per
One inadvertent typing mistake here and there will not make an order invalid. Come to the core issue that this death
the actual fact of this
Ha.
case.
in the circumstance how the death was occurred, railways are not liable to pay any compensation. Argue your case.
It is not the 4 issues that framed, my lord. At page 14, para 4. Issue number A, whether the deceased was the bona fide passenger of the train carrying passenger.
Why do you say he is not a bona fide passenger?
Because, my lord.
Now, what finding the tribunal arrived? Let us see the
Yes.
let
My
us
lord, you can-
let us see the finding of the
Yes,
tribunal.
My affidavit, my lord, I'll only.
Forget your affidavit. In appeal, we are not going to any affidavit.
Says, under issue number 1,
Appeal will go by the records
Yes.
and the material level. That's all. We don't want any affidavit here.
in issue number 1 at page 15, my lord, RCT observed that it is the case of the applicant that disease was traveling on a valid ticket bearing number so and so dated 48 to 12 from the Palasa to Guwahati in Trivandrum Express. From the state journey ticket, it revealed that ticket was purchased for the journey from Palasa to Guwahati. The applicant examined AW1
and state on the oath that her husband, late Sanjay Kumar Rai, was traveling in the state train on the strength of above ticket. The above evidence laid by the applicant was unchallenged. No evidence at all has been adduced by the respondent to disprove the bona fide journey of the disease. The respondent has also not challenged the genuineness of the journey ticket produced by the applicant, except mentioning that ticket recovered from the disease is outdated and that cannot be treated as bona fide. However, in
Madam Chakraborty,
the
the respondents has also not challenged the genuineness of the journey ticket produced by the applicant.
Yes.
Except mentioning ticket is outdated. So this is your stand. It is Section 106 of the Evidence Act. It is for the railways now to give evidence to show that this is an outdated ticket. Where is your evidence?
My lord. Yes, my lord. In my CD, my lord.
CD.
Yes, case judgment.
CD
They have made inquiry from where it is found that these tickets are outdated from Kokrajhal to Visakhapatnam. This outdated ticket. But as
No.
per their statement, he purchased ticket from Palasa to Guwahati.
Maybe, but you have to, it is the burden of proof is on the railways to show that it's an outdated ticket. Please show us the material on evidence, reading which we will come to a conclusion that it is outdated.
My lord, from the report, CD, my lord, it is evident that.
Was the CD exhibited?
Yes, I have filed an affidavit.
Your affidavit, we are not interested. We are hearing an appeal.
Yes, my lord.
Appeal will decide it as per the evidence already on record.
The respondent submitted all the report to the claim tribunal.
Madam Chakraborty, we understand what has happened to you. Your lawyer is not doing the required duty there. He is more interested in having his cup of tea in the canteen, possibly. He have collected a bunch of paper and thrown it at the tribunal. Yeah, here it is. Evidence means you have to prove it through evidence. Just placing a bunch of papers is not providing evidence. See how evidence has to be rendered.
Yes.
And once it is the stand of the railways that the ticket produced by the claimant is an outdated, the burden of proof will shift on the railways now to prove that this is outdated.
But,
And you can produce any relevant evidence to show it is outdated. We are asking you for the third or fourth time.
my lord,
Appeal is not decided on arguments, Madam Chakraborty. Appeal is decided on material on record.
yes, ma'am.
Take the record, show us the evidence on record, which will show it is an outdated ticket. We'll allow your appeal.
You are
But we are not ready to hear all this, all and sundry and stating whatever you want to say.
CD. Now we have to go to the CD.
Go to it.
Okay.
Show it. Which material will prove it's an outdated ticket? Straight away, it will be dismissed. Don't worry.
May I look at-
But we can't dismiss allow an appeal on the ground of some affidavit filed, some inquiry report here and there. One statement in some inquiry report, somebody says, these are not materials. You could have brought in the evidence of the booking clerk that this ticket is outdated because on the day it is claimed to have been issued, I did not issue this ticket. This ticket must have been issued much prior to that. If the booking clerk comes and gives the evidence, you are true. But difficulty is, railways are always very vigilant in appeals, but before the tribunal, you almost do nothing. What is it? What is it first? First of all, what is it?
In the 16, my lord. during
What?
the-
No, no. Firstly, tell us what is page 16. Only then we'll take a look at it.
CD, my lord.
CD.
CD, final report, CD.
CD is not admissible in evidence.
My lord, there is what is some there.
Even in a criminal case, a CD is not admissible in evidence unless the IO proves the CD.
In this, IO was a chief secret commissioner.
Okay, we are dismissing the appeal then. Either you produce or you dismiss.
Now, is a lot of please.
Railways are how much crore?
My lord,
Some
actually,
40 lakh crores of a organization. One man died, he is giving 4 lakhs. And the legal expenses of the railways must have exceeded 4 lakhs by now in carrying this appeal for the last, I don't know how many years.
now, as the we have railway. has
Unless you have a,
whether it is outdated ticket or not, my lord. And then initial burden lies on the claimant also.
no,
If-
this is the argument we reject on a simple ground. Whatever evidence is produced by a litigant, by a claimant, that is evidence on record. If it is 10 unit of evidence, still it is an evidence. If it is 1 unit of evidence, still it is evidence. Whatever is produced has to be rebutted by the other side.
That's right, yes, sir.
Merely by making a claim. This is happening in those foreigners cases also. It is only taking a stand that whatever is proof is not adequate. There is no provision in the Evidence Act which will say that whatever proved is adequate or not will also be a question for determination. If the evidence is rendered, remains unrebutted, it is an admissible evidence. So it is for you to produce relevant material to show it's an outdated evidence. Produce the evidence, we'll hear you. We are not interested to hear any other thing.
I will.
We granted you over last occasion also.
Report,
And Madam Chakraborty, on the last,
my lord.
Madam Chakraborty, on the last occasion also, the same arguments were made by you. Same questions the court has raised. Same way the court has explained what is required.
No, man, is the question.
Same
that I-
submission was made. Give me some opportunity to examine.
No, man.
And today is a exact repetition of what had transpired on the last day of hearing.
There's a one prayer, my lord. If
We'll take it up at 2 o'clock. Look at it. Okay, we are giving you time to examine.
no, my lord, simple, I want a single word I will submit, man, single line, my lord. If one suspicion arises, if he has a bona fide ticket. what is the
Madam
agreement?
Chakraborty, suspicion is only for the railways, not for others. Neither for the court nor for the claimant. Only by raising one hand above, I suspect it. The burden automatically does not shift. You'll also have to substantiate with material why it is.
My lord, it is difficult.
It will be difficult. As I told you, your authorities are not doing their duty in the tribunal.
Yes.
That is the
Very
reason.
good.
That
Sir,
is
now,
the
Lordship,
reason you are in
Lordship,
difficulty
please, my
now.
lord. Lordship, I don't have to say anything more. Lordship, please.
Definitely, that is the only It's
Yes,
not
ma'am.
what we please. It is what you please.
No, he, Lordship, please, and we also please, my lord.
No, we are telling you, produce the material to show that you have discharged the burden of the stand you have taken. Or else, point out the relevant provision in the Evidence Act, which is that merely raising one suspicion is also amounts to discharging the burden.
In section 101 also in Evidence Act, my lord, initial burden lies on the claimant who is claiming.
How many times will you repeat the same line? They had already discharged the initial burden. They gave complete evidence and also exhibited the ticket, that this is my ticket. And what more burden they have to discharge? And it is you who take a stand that this is an outdated ticket.
But no,
Once it is your stand, burden shifts on you to prove it is an outdated
yes,
ticket.
correct, my-
And I told you how could you have done it. You could have got your,
Further,
you could have brought in your booking clerk for giving evidence. On that day, it was me who was manning the booking counter. This ticket was not issued on that day. Enough. You don't need anything more than that. You don't need your CD, you don't need your enquiry report, you don't need your officers. One booking clerk is good enough. But you don't do.
that time.
And no one applies your mind in the tribunal. We'll observe if you want that your officers aren't applying their mind. If you want that observation, we can give it. And we are very fair for that. It's the second or third day on the same issue. Show us the evidence, and even not complete evidence, even an iota of an evidence where the railways has discharged the burden that this is an outdated ticket.
During the pendency of the claim petition before the RCT, my lord, railway has not challenged this ticket. It has remained unchallenged.
What can you do?
Then
You
that's
issue
why
a show cause notice to your officers and the lawyers for taking action.
No, the RCT observed that, my lord. But they have a written statement. They said that
Very well.
there is no eyewitness.
For every occasion, eyewitness is not required. Eyes are not open everywhere. That you'll have an eyewitness for every moment in this world.
Then where from this wife? No, I'm out of this argument, madam. Where
You,
from this wife got
Madam
this ticket?
Chakraborty, if you want a law class to be held, we'll organize for a seminar, we'll tell you. To answer this question, not in a court of law.
Where from this? It is a.
You know, as a lawyer, it's up to you to say the answer.
No, the lordship. I'm the only.
Every event that has taken place in this world is not required to be backed by an eyewitness. If otherwise materials are good enough to substantiate it.
Correct, lordship.
So now which eyewitness? Only eyewitness who had purchased the ticket is the dead man. Can you bring him back to give eyewitness evidence that I purchased the ticket from the counter on that day? Then. Or the wife is now required to find out who was the man standing behind the deceased in the queue to purchase the ticket. Bring him and give an eyewitness, yes, he had purchased this ticket. There's a level of absurdity also, no? Representation. Merely raising stance is not sufficient in a court of law. Therefore, we have Evidence Act. Therefore, there is a requirement of law to discharge the burden. But till now, frankly, I have not found any material. So I asking you, if you have, please point out.
No, madam.
Nothing is there. So we close this appeal. You have got the money or you have stayed?
No, we have not.
Pay with interest. For 2015. One widow, you had deprived the money for the last 8 years, mind you. Was your officers ever compassionate on this aspect? What would have happened if your officer would have died in that accident and his wife would have filed that thing? Would he have behaved the same way? Make a reasonable assessment. Suppose the claim is an absolute fraud claim. Bring it before us. We are going to even penalize the wife also for making false claims. But no rhyme and reason, file one appeal. Ensure that the appeal lasts for around 8 to 10 years. Get a stay.
11 years.
11 years now.
Yeah.
See the unfortunate aspect of the incident. And this widow must have spent a very difficult time. And you as a woman know what is the state of a widow when the husband suddenly passes away. Why the law provides for this little bit of 4 lakhs is almost nothing in nowadays. Why does the law provide for it? That is some succor to the family. And that also you are depriving. And with all these frivolous grounds being taken. What ground? We have one CD. CD is not even exhibited, not even proved by anybody. Plus CD is not an evidence. CD is only recording of statements by some investigating officer. That is not evidence. And if recording of investigating officer is evidence, almost everybody will be subject to death sentence tomorrow. Why? Because the IO had written one line in the CD. Sent him for life imprisonment. Is that the law? Next one, you say there is no eyewitness. Where is the relevance of an eyewitness? The applicant widow comes to the court, produces the ticket, that this is the ticket my husband was traveling with, it was purchased there, exhibited it. In appeal, you take one vague ground, it is outdated.
No, I am not telling
Please,
that.
enough of all this. We may impose some cost in this appeal also. And the railways are known in what circumstance they file appeal. In one matter, about 2 to 3 years back, cost was imposed because the subject matter was, the appeal was so small an amount, the legal expenses undertaken by the railways was about 100 times more than the amount. This is how your law department is functioning. I think Justice Surana, I think one order is the judicial order is the imposing cost. Yes, on a regulation basis, file an appeal, get a stay. And these are all benevolent provisions. And where crores of rupees is being wasted, no one is bothered about that. 4 lakh to a poor widow, 5 to 10 nailed against it. Yes or no?
Now after I lost it, I don't have to say anything.
It has to be. Look from a little broader perspective. Again, we are telling you, if you have any material to show that this is a fraudulent claim, tell us. We'll seriously look at such as that. Because no one should be allowed to defraud the railways by making false claims. Nothing is there. I don't think anything is there. Third MS U. Chakraborty learned
Special senior
counsel,
railway.
special senior railway counsel for the appellant railways. Also heard Mr. G. Mullah learned counsel for the respondent claimant. Srimati Ganga Roy instituted a claim under Section 16 of the Railway Claims Tribunal Act 1987 for compensation on account of death caused to her husband Sanjay Kumar Roy while he was traveling from Palasa. Palasa, where is it located? West Bengal or Orissa? From Palasa in Orissa to Guwahati by the Trivandrum Express on 14/8/2012. The deceased husband of the respondent claimant fell down from the train, sustained grievous injuries, and he was shifted to a hospital where he had succumbed to his injuries. The fact that the husband of the petitioner was traveling from Palasa to Guwahati by Trivandrum Express on 14/8/2014, and he died as he fell down from a running train, from the train, upon sustaining grievous injuries, is an admitted position of the appellant railways as well as the claimant, in as much as that there is no denial by the railways on the claim that the husband had died in the manner indicated above. The tribunal in its order judgment dated 18/6/2015 framed an issue invert comma as to whether the deceased was the bona fide passenger of the train carrying passengers. The said issue has its relevance from the point of view that under the Railway Claims Tribunal Act equal to the said issue. Anyway, Railway Act that under section 124 capital A of the Railways Act 1989, when in course of working of a railway an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of the railway administration, such passenger who has been injured or the dependent of such passenger who has been killed are entitled to a compensation as may be assessed. Untoward incident কি হলো around 9 to পড়াশোনা said issue মানে said issue to under say full stop. In other words, in order to be entitled for compensation under section 124A of the Railways Act 1989, the passenger concerned who is injured or who may have died ought to have encountered an untoward incident. Which expression is again defined under section 123 bracket 2. And then key and 123 bracket C bracket 2, which also includes accidental falling of any passenger from a train carrying passengers. Where again, Section 229 of the Railways Act 1989 defines passenger to mean a person traveling with a valid pass or ticket. In the aforesaid context, we have the relevance of the issue as to whether the deceased was a bona fide passenger of the train carrying passengers. Meaning thereby as to whether the deceased, in order to include the act of death having been caused to the husband of the petitioner would be an untoward incident, there would also be a corresponding requirement to find out, to arrive at a conclusion as to whether he was a passenger, which again would mean as to whether the deceased husband of the petitioner was traveling with a valid railway ticket. It is in this context that the issue number 1 was decided by the tribunal in its judgment dated so and so, wherein the tribunal arrived at its satisfaction upon the evidence rendered by the claimant that the deceased was traveling on a valid ticket bearing number B92906311 dated 14/8/2012 from Palasa to Guwahati in the Trivandrum Express. To this extent, the applicant also examined herself as AW1 and stated on oath that her husband, Sanjay Kumar Roy, was traveling in the said train on the strength of the said ticket. The tribunal categorically arrived at its finding that the said evidence rendered by the claimant and also by producing and exhibiting the ticket bearing number so and so had not been challenged by the respondent's railway authorities. It is only a stand taken by the respondent authorities that a ticket number so and so exhibited and relied upon by the claimant is an outdated ticket and therefore
This is not outdated ticket. The ticket which is recovered from the possession of the deceased man, these are outdated, 2 tickets. The claimant to whose
go to Supreme Court. It's clearly written at page 64 where I'm quoting it from there, not from any what the railway wants. Is outdated. Whatever ticket was produced, relied upon and exhibited by the claimant, if it is the stand of the railways that such ticket is an outdated ticket, in order to prove that the deceased was not a passenger traveling with a valid ticket, the said ticket, once having been proved and exhibited before the tribunal, the burden of proof under the Evidence Act would now be on the railway authorities to bring in further evidence to prove that the ticket concerned is an outdated ticket. We need not advise the railway authorities as to in what manner the claim that a ticket was outdated can be proved by bringing evidence. But upon perusal of the evidence on record, no such material is available that the said ticket had been proved by the railway authorities to be an outdated ticket. We even required the learned senior counsel of the railways to peruse the records and bring it to the notice of the court as to whether any such evidence is available. But no such evidence or material could be found in the records. The learned senior for the designation is very complicated. What senior?
Special senior railway.
Special senior
Railway council.
railway council. The learned special senior railway council. কি করলো? The special senior railway council, special senior railway council merely takes a stand by referring to the case diary of the investigation and points out that there is a particular sentence in the case diary that, what is your sentence?
The ticket from, the outdated ticket from Kokrajal to Visakhapatnam, but train number 7, it is outdated.
That the ticket is outdated. A statement available in the CD cannot be material in evidence before a court unless such statements are again fortified by appropriate evidence. No such evidence, it's against, no such evidence is available on record. As the only ground taken by the railways in the present appeal that the death of the husband of petitioner was not an untoward incident inasmuch as he was not a passenger traveling with a valid ticket. And as the railway authorities could not refer to any relevant material on evidence which may show that the ticket relied upon by the claimant was not a valid railway passenger ticket, we had the view that the appeal has no merit for interference of the judgment dated so-and-so of the tribunal. It is noted that the tribunal by the judgment dated so-and-so had awarded a compensation of rupees 4 lakhs in favor of the applicant for the death caused to her deceased husband. We have been also informed that in the appeal instituted by the railways, there is an order dated 26/5/2017 providing that the judgment dated 18/6/2015 shall remain suspended. As the judgment remains suspended, the consequence thereof is that the claimant is yet to receive the amount of compensation. It's rather disheartening to note that the accident took place in the year 2012, which is not denied. And the claimant is yet to receive the compensation amount for the next 11 years. And that too, by raising a ground in the appeal, which does not appear to be supported by the materials and evidence on record. In the circumstance, the respondents in the railway authorities are directed to pay the further. No ground has been taken in the appeal, either assailing the quantification of the awarded amount, nor any other ground had been taken. In the circumstance, the responsible authorities are directed to pay the awarded compensation to 4 lakhs to the applicant with interest of. What's the interest nowadays?
RTP or interest at the rate of 6% from the date of filing original application. And
Madam Chakraborty, if I want a loan from the railways, will you give me at 6%?
the RTP order, madam.
Understand?
RTP
Suppose Madam Bhuya now wants a loan from the railways, will the railways be ready to give it for 6%?
no, madam.
Mr. Mohan will be very happy to take that loan. Immediately he'll ask for it. He'll give me. Yes, something more reasonable, something a little compensatory also. At the rate of 9% per annum, which may be to some extent equivalent to the rate of interest as may be available for a fixed deposit, had the amount been kept in fixed deposit as awarded.
In the examination, there might be some
That again
technical.
depends on what instruction Mr. Fukan can provide.
Lord, I have talked to the controller and
Hmm.
minister.
No, otherwise it appears to be a genuine case.
Lord,
But not that,
page 25 goes against the petition.
which one?
Page 25. Lord, if it would have been JE or NEET, Lord, is the
Page
Lord,
25.
Page 25.
Just
The papers.
page 25, huh?
The paper, it was for 3rd semester. It should have 5 papers, but this paper is for 1st semester back paper,
That's not 3rd semester.
not 3rd semester. That is why, Milord, the entire problem revolves around this page. If it would have been, Milord, JE.
Understand? Understood.
Because my lord, the petitioner has a one area paper, man, for 1st semester. He has applied and submitted a form for the 3rd semester as well as the back paper. The back paper.
3rd semester results are out.
No, only the back paper has result. He got the result. But
This
the
is
third
the
semester-
back paper, he got the result.
Yes, yes, ma'am.
And 3rd semester
Third
not.
semester result was not.
So he has come up, what he has done, the mistake in the form, instead of 5 subjects, he has written the subject which is of the back paper. That is the mistake. But we
He should
allowed him
have
to
been
say.
vigilant enough. He should have been
No,
careful.
but
Milord. That is the problem.
we understand. Technically, you are right. We are not saying anything against
We allowed him to say, appear, the answer script forwarded to the zone. and
I understand, Milord, that as an interim measure, the college authorities having no other way, as an interim measure, allowed him to appear. To take a call on the.
Yes,
matter.
what do you say?
My lord, because my lord, in the at the time of filling up the form, I have already filled up all the forms and submitted to the college authority. At the time of.
No, no.
Yes, my lord.
Where is the form submitted by him? Where is the form submitted by the petitioner? Let us see.
And he has not annexed that back area paper.
The form is the same form as the third.
Mr. Gogoi. See, it's a very delicate situation.
Yes.
Whatever lashes were there on the part of the petitioner, don't try to cover it up and manipulate it. Okay. If you do that, we are going to dismiss the petition. If you are not fair to the respondents, you are not fair to the court, we are going to dismiss it. If you have committed a genuine mistake
Yeah.
inadvertently, accept it. We are just trying to explore what further can be done.
Yes, fine.
But if you are trying to make wrong manipulating way, and if we detect, we'll dismiss the petition straight away.
Lordship, I have
Court is not
marked
bound to take note of any manipulations.
Okay, I have marked them. One back paper form. Okay, this, the subject is. Subject is BBA 801016,
First semester
mathematics techniques and business.
Nowhere the 5 papers have been indicated.
Both the form, the subject is same,
Board of Forms subject is
same.
which subject? That BBAG,
BBA, that is
mathematical
sub-
technique.
It's a back examination,
First semester.
first semester,
This is the first semester.
Yes.
And what is the third semester papers?
5 papers.
The,
In my board, it's there.
Not indicated.
It's not indicated in the form.
Acha,
That
he
is the
did not
mistake
indicate.
He has committed. But he appeared in all the 5 subjects.
Understand? So, Mr. Gogoi, apparently you have committed a mistake. Now, why are you trying to show pages here and there and try to justify that you have not committed? See, there are 2 approaches you can take.
Yes.
One, try to justify that they are all wrong and I am only right. I have done this, they are not accepting it. Then you are bound to prove it, number 1. Once you fail to prove, end of the writ petition. We are not going to entertain it anymore. Other one, you admit, yes, it is a genuine mistake I have committed. Then we can explore
Yes.
with the authorities what further they can do to help you. So now, which of the 2 you want to adopt?
I admit-
Take your course straight away. If you say, no, I was right. I have submitted everything in a correct manner, but it is the authorities who are at fault. We'll allow you to take that stand, but the consequence will be if you fail or if you make wrong incorrect statement, misleading facts, it will result in a dismissal of the writ petition. Other one, yes, I admit every mistake what is said. Once you are fair to yourself and to the authorities also, we may explore with the authorities if it is possible to do something. We'll look into all the laws governing the university and the college and see whether any of the laws can be taken advantage of to take care of your problem.
Admit it, my lord, since I have.
You are admitting. So you are not trying to.
Yeah.
So fact is, in your application form, you did not mention the subjects of third semester. And admit card will be issued on the basis of that application.
Yes.
So they are not wrong in not issuing the admit card.
Yes.
What are the laws governing the university in this? Do you have any inherent power?
Yesterday also we had that case in the
Uh,
law center thing.
Do you have any inherent
Inherent
power
Under section.
under
License.
under the normal regulations? You don't have. I understand. I fully agree with you. But in an exceptional circumstance, do you have any inherent power?
Under section 8B4, the vice chancellor power.
8B4
And it should be read with section 23 of.
of the Guwahati University Act.
Yes.
Some Guwahati University Act.
Third edition, Diwan or.
Yes, second.
Collector.
8B.
8B4. It should be read with section 23 of the clause.
And 23.
On 23, General Clauses Act.
Hmm?
Assam General Clauses Act.
General Clauses Act.
It should be read with
General Clauses Act from some.
Assam General.
This is an extraordinary power in an emergency situation.
Afterward, he will inform the authorities.
Uh,
That means
then-
the controller of action.
Instead of the authorities taking, he will take the decision and inform the authorities that I have used my discretionary emergency power to do this. I think that's the only way out.
Section 23, Assam General Clauses. 23.
Assam General Clauses Act or the General
Assam
Clauses Act.
General Clauses.
Assam is a separate act.
Yes. 1950. Section 23, Assam General Clauses. 1950.
Has any judgment been rendered on 8B, 8B4 till now? Circumscribing that what is emergency?
In some cases, it has been reflected, but
No. Has any court gone deeper into it? Means what will be excluded to be beyond
to my information,
8B4?
there is no such judgment. The power.
But we would like the deputy vice chancellor to now to frame a rule scheme this to dilute it. This is not required for the purpose. So general clauses at 23, I don't think we should invoke that. Only compassionate, sympathetic consideration is student. Whether we can prevent him losing 1 year.
It's a court of equity.
And
That also means-
secondly, there is nothing fraudulent from the side of the student. Means he did not, by an act, he did not deliberately try to take advantage of something which is not entitled.
And,
Because he is definitely entitled to file that application with 5 subjects.
and in my opinion, the college authorities have also have not done any wrong.
No one has done wrong.
As an interim measure.
Hmm.
he
Now,
has
what
been
to do?
allowed-
Had he not appeared, even that also could not have been evaluated. So at least now we have those answer papers with you to do something.
Result has already been declared regarding other candidates.
No, definitely.
But whether that paper has been evaluated or not.
Any proposition of Supreme Court that if something is done inadvertently, without any fraudulent intention, and by an act which otherwise would have taken advantage or bestowed some right or benefit which otherwise the man is not entitled. In that case, equitable consideration can be made that he should not be deprived of the benefit. Is there any such a principle available? So that we can invoke that, that's the only way out, no other way out.
Come up on Wednesday.
Yeah, definitely, not today. Even I'll go to it.
That Vista case,
Ah.
Supreme Court. that,
No,
regarding administrative
no,
discretion.
basically, these rules are governed to regulate the procedure. Unless you don't have these rules, it will be a chaos. Anybody will go at any time. So you regulate a procedure by which these acts are to be performed. This is the last date, you submit it in this format, place it before this website, it will go there. The definite down the line procedure is there. Ultimately, it will reach the university will analyze it, issue an admit card, and the man will appear. So technically speaking, nothing wrong with that. In university could not have issued an admit card without there being an application as to in what subject it is required to be issued.
Otherwise, there will be a floodgate of.
Definitely,
applications and
everybody
there
comes.
Negative cascading effect
Ah,
in the entire state.
but only that's the only principle. But in a given situation, a man is otherwise entitled to the whole thing. There is no impediment of any kind. It's only a regulation thing that he has to put in a form for this purpose. And in doing that, somehow he misses out and writes an incorrect information. Incorrect information ordinarily is a good reason to reject it. Why? Because the incorrect information may lead to an entitlement to that person, which he otherwise would not have been entitled had the correct information been given. That element is absent in this case. In the absence of that element, can equity have a play? As a one-time measure without precedent?
My lord. Since it's a court of equity, and there are two vital aspects, my lord, which goes in favor of the receipt. One, he has submitted that form with that rupees 750. Here. Fees has been paid. Second, he appeared in the exam. He has been allowed to appear.
No.
Two vital aspects.
Later stage is there, and plus he is not trying to take advantage of anything. So, what is the age of the student?
My lord,
College will definitely must be major. Had it been a minor baby, you would have taken another view.
Thank you.
Must be major college.
Date of birth 22/8/2002. So 21 years.
21 years. Okay, we'll hear you again. You also see what can be done. Yes, Madam Bhuya, you also,
Pencil on the part of the.
you are going as a, from the point of view of criminal law. You also think about it. When do you want? Fix
On
the
Wednesday, my lord.
Wednesday, Pari?
The principal presence may not be required.
No, they are not required. This was required for one specific purpose, that a statement is made, and you also, Mr. Gogo, you were telling you don't make incorrect statements. We deprecate that. To enhance the intensity of your matter, we cannot allow you to make incorrect statements requiring the presence of the principal. Okay? Because we give great sanctity to the statements made by the learned counsel. If you feel that by making a more intense statement, I am going to get an advantage, you will get it. But when it goes against you, it will hit back at you.
Because they have.
You know what is a boomerang? Boomerang. Have you ever heard the word boomerang?
Yes, my lord.
What is
Yes,
it?
yes.
What is it?
If we use, and it will come back to you after.
In
hitting somebody else.
which country it is related to? And which community?
Africa, maybe.
Which
Yes.
country and which community?
Community, I think.
New Zealand Maori community. It acts like a boomerang. When it goes out very fast, it will hit your object you are trying to hit. But if you miss, it will come back and hit you again. Why did you make that false statement? That the principal on, I had filed correct application, principal on his own had not forwarded it. And therefore I am suffering. Why did you make that statement?
My lord, we have.
You
filed-
could have been fair to everybody.
Yes.
Say that, see, there was a inadvertent mistake committed at me. This happened. Please look into it.
May I submit
Your-
something?
Approach Mr. Gogoi with deprecate, mind you.
My lord,
We are only taking it.
Yes.
Not for the statement of wrong statement of Mr. Gogoi
Yes.
and trying to show his legal acumen as a lawyer to enhance. We are not on that. Only thing in equity, we are concerned with the student before us.
Yes, my lord.
That's the reason. Please don't do it.
My lord, may I submit one thing?
Don't submit. You had definitely made a wrong statement leading to the personal presence of the principal. And today it reveals it is an incorrect statement. We don't have to hear anything more than that from you. Please don't do it. Be fair. Be fair to everyone, you will get a fair treatment. I know that's a theory of lawyering nowadays. Try to put in some more intense statement and try to influence everybody. That's the worst of the habit a lawyer can develop. And mind you, the consequence is next time Mr. Gogoi comes, we will be once bitten, twice shy. We'll be more careful. We may not act on your statement. Other day, merely on your statement, we have acted on it. But the next time, we are going to verify everything. Okay, thank you. Please don't do it.
Still one RTI application was filed and they have, my lord, stated that no application has been submitted.
Where is that RTA application?
Yes, my lord. The reply of RTI application, my lord, as page number, my lord.
Who had given this RTA reply? Let us see.
At page number, my lord,
Relevant document.
44,
Page number
44, my lord.
44.
Annexure 9.
It's all right. BBA
Yeah.
third semester regular.
Regular
exam.
exam.
Did not submit the relevant documents of a form. Right.
Correctly.
You are not written the subjects. Should be more careful. Otherwise, you would have dealt with the matter in a different manner. We would not have required the principal to spend a whole day in the court for this thing. He has many other responsibilities in the college, other than this attending to your needs. You would have got the relief if you can make us understand it, but you would have done in a different way. But there will be a strong statement that I have submitted the application, the principal is not forwarding. Definitely the response thereof will be, will go a little against the principal. Why will you not do it? Why will you make a student to suffer? Be careful.
He's
No,
Dr. Bhavavati Sharma, Vice
Dr. Bhavati Sharma, the vice principal of the college, is present as per requirement of this college. The records have been produced. We are satisfied. List for further hearing also. Thank you, Principal.
Can we get the? I have marked
You
it.
take back everything.
Twenty-seven and 28.
Yes,
May
ma'am.
I please your lordship? Apology, my lord, my senior age Burago is in still legs in.
Adjourned on the prayer of inconvenience of Mr. H. Buragoin and counsel for the petitioner.
I adjourned the matter.
Adjournment cost of rupees 10,000, it being a matter of 2015.
My lord, he is still in legs in court number 17.
What to do? We can't wait for a whole day.
Kindly adjourn the matter.
We have adjourned. We have not refused your prayer.
My lord, without the cost.
Cost to be reduced, 5,000. 2015 matter. You should give preference to these matters also.
Your order has been delivering over.
Doesn't matter. Everybody is a lawyer. Mr. Mohanto knows how to regulate his business for the day. Where to give preference, where not to give preference. Preference to the other matter, maybe for some other reason. Non-preference for this matter, maybe for another reason. Yes, adjourn karo when do you want?
Next,
Ensure
your
that you
lord-
do it next
As
time.
per your lordship. Obliged.
Next time, what do you say?
Timing item 40.
Yes, Mr. Mohan.
Yes,
What is
sorry,
this
madam,
matter?
last half, my lord, I was preparing division bench, that's why I'm
Sorry.
First half, my lord, I have an applying division bench, that's why I'm.
No, no, doesn't matter.
My lord, here petitioner, my lord, is the senior most eligible teacher of the, my lord, for the post of.
Mr. Monto. I think we have to release it from Pardhat. Your matter, we are adjourning it, but we have to release it from Pardhat. We start all over again in some other court. Okay. না লাগে পাঠান রিলিজ করে থাকবে এটা তুমি লিস্টটা release from Pardhat because I don't have time to hear it anymore. Already my board is already full. Okay.
Obliged.
Sorry. Post of principal of the, my lord, Agamani High School is lying vacant since 31/8/2023, my lord. Then, my lord, inspector of school forwarded name of the eligible teacher who can hold the post in charge principal, and accordingly, principal, my lord, forwarded the name. I am the most senior most, my lord, eligible teacher to hold the.
But given to somebody else.
Yes. So he has submitted it. Then, my lord, that director passed an order that is the impugn.
The petitioner is otherwise eligible.
Eligible.
Is there any infirmity in the eligibility? Nothing.
No, nothing, my lord. There is a order passed. Your lordship will find it page 29, my lord.
Page 20.
Next, sorry. There is the small order, my lord, that I have no permission to while doing B.Ed, I have not taken permission.
No, that is already gone.
That is already your lordship.
Yeah, it's already decided.
Is there that your lordship region order I have seen.
Mhm.
But in fact, here in my case,
You have taken permission
I
also.
am taken permission from principal and I have given by the inspector of school also. And also the application form, I have to submit
No,
one.
by this one is somebody else made. Habibur Rahman.
No, your lordship kindly see the impugn order, my lord.
I have read it. No, had Habibur Rahman not been made, I would have interfered and sent back the same day itself. That take note of this, the factual
No.
circumstance pass over, but
No, that your lordship kindly is not happy more on the part. He's the second senior most.
I
He's
know,
also
but
he's also equally not same ground.
yes, complete state.
After
No,
not-
oh, again, same one. Therefore, until further
I am
order,
not-
inspector will,
I am Nozul Islam, first para, my lord.
let us interfere, set aside, send it back.
My lord, that is my
I
plan.
think that is better because
They already your lordship region order
because
passed.
the college suffers with the inspector
Yes.
being the in charge.
Now hand over the search to inspector. of school.
Inspector, he will only, what will he do?
My lord.
Only a cursory attention at the school, or if somebody reminds him that you are also a in charge principal, school will suffer. Let
That's
me be a person. That Mr. T.J. Mohantal and Senior Counsel for the petitioner also heard.
Secretary.
Also heard. MSS Chutial and Council appearing for the Education Secondary Department of the Government of Assam. The petitioner Nazrul Islam. No. The petitioner Nazrul Islam. The name of the petitioner Nazrul Islam, along with 4 other teachers of the school, were forwarded by the principal of the school,
No, by inspector. of school.
by the inspector of school to the director of secondary education Assam for being the in charge principal of Agomani Higher Secondary School in the Dhubri district.
Dhubri.
In the Dhubri district. Accordingly, the matter for appointment of the in-charge principal was processed, and by the order dated 16/10/2023 of the Director of Secondary Education Assam, it was provided that until further order, the Inspector of School Dhubri would hold the charge of principal of Agomani High School, Higher Secondary School, along with financial orders. The reason thereof is stated in paragraph 2 of the said order that the petitioner Nazrul Islam, who has the qualification of MA and B.Ed, is otherwise the senior most teacher of the school, and he would have been eligible to be the in-charge principal. But the director had taken note that the petitioner Nazrul Islam had acquired his B.Ed degree from IGNOU in the year 2014 without obtaining prior permission from the appointing authority, and therefore the provisions of section 13 of the Assam Civil Services Conduct Rules 1964 is violated. The order also records the provisions of Rule 13 of the Rules of 1964, which provides that no government servant while in government service shall join or attend any educational institution for the purpose of preparing himself for or shall appear at any examination of a recognized board or university without obtaining prior / previous permission from the appointing authority. Similarly, another teacher of the school, Habibur Rahman, who also has the qualification of MA B.Ed, but otherwise second in the order of seniority after the petitioner Nazrul Islam, was also refused to be the in-charge principal on the same ground that he had also obtained his B.Ed degree from IGNOU without obtaining prior permission from the appointing authority. The implication under the law of obtaining B.Ed degree without obtaining prior permission had been decided by this court in its judgment dated so-and-so in WPC so-and-so.
That I have given, that is I have given.
In this one, my judgment, that's a complete one. No, later on I had made some more ones.
Vacation in PIN order.
No, Mr. Mohanto. In one matter, I decided the complete law. In the others, and the others have followed it. This is the original one or the later.
Actually, I have to find it out. I'll find.
I
have seen that.
In the judgment, and I think this is the one. The order dated 28/9/2023 in IS Civil 2615/2023. Full stop. As per the proposition laid down between Mosumi Soharia, IS Civil, (Dibo), Mosumi Soharia versus Smriti Rekha Kolita and 3 others. In Mosumi Soharia Supra, a proposition had been laid down that if a government employee obtains an educational degree from a board or an university without obtaining prior permission from the appointing authority, under Rule 13 of the Rules of 1965, it may be construed to be a misconduct. But such misconduct cannot render a degree otherwise valid in law awarded by a board or a university to be invalid, so that such degrees cannot be taken into consideration while further assessing the career prospect of such persons. A degree awarded by a university would be governed under section so and so of the UGC Act of 22 of the UGC Act.
1952.
And no other authority would be empowered to either declare such a degree to be invalid or not take note of it other than the UGC itself. From such point of view, the order dated 16/10/2023 of the Director of Secondary Education, in refusing to take into consideration the B.Ed degree of the petitioner as because it was obtained without obtaining prior permission from the appointing authority, would be unacceptable in law. At the same time, Mr. T.J. Mohontol and Senior Counsel for the petitioner has also made this statement that in the instant case, the petitioner Nazrul Islam had obtained the permission from
From the principal as well as inspector.
the principal as well as the
Inspector.
inspector of schools. Page number,
Page number 20, 19 and 20, madam.
school.
Page number 19 and 20.
As per the certificate of the principal dated 14/7/2011, available at page 19 annexure 2 to the writ petition, and the endorsement of the inspector of school available at annexure 3, page 20 to the writ petition, which prima facie discloses
And also page 21 and except for my lord, that is a experience certificate. I have to submit it along with the form, my lord.
which prima facie discloses that the permission contemplated under Rule 13 of the Rules of 1965 had been obtained by the petitioner.
Competent, appointing authority is the direct from my lord. It is given by this.
Had been substantially complied
My lord.
by the petitioner.
That is there.
In view of such infirmity, upon understanding the implication of Rule 13 of the Rules of 1965, as well as there being a requirement to verify the factual information that whether the petitioner had obtained any permission, comma, the order dated so and so is set aside and the matter remanded back to the director for passing a fresh order by taking note of all the attending facts and circumstances as required to be taken, as well as those indicated herein above.
My lord. So the school is suffering, my lord.
We have heard MSS Chutial and counsel for the Secondary Education Department of Government of Assam, but instead of issuing notice, we deemed it appropriate that the matter requires a final adjudication in as much as in the event the order dated 16/3/2023 is stayed, 16/10/2023 is stayed, the Agomani Higher Secondary School would be without any in-charge principal. And on the other hand, if it is not stayed, it will be the inspector of school who will be the in-charge principal along with his other duties he performs as an inspector, which again may lead to a situation where the school would suffer. Considering the balance of convenience, we deem it appropriate to pass the final order as indicated above. The balance of convenience as well as the irreparable loss that the school may suffer. Otherwise, somebody will question her that why did
Yes,
you?
If state, my lord,
We are
still,
saying, we heard you, but we have used our discretion to do it.